finish. Probably gonna finish. There'll be a little bit left over for our next class on Thursday, and then we're gonna on Thursday also start the conflicts material, and that's gonna be chapter 6 through 10, various different types of conflicts. So the reason that we have been, before I say that, after this class, Professor Giesel is giving her annual Flexner lecture. It's gonna be on alternative litigation, I think, and financing arrangements for those alternative purposes of litigation. Always promises to be an interesting lecture, so you're invited to stay after this class for the lecture. I think there'll be food to us. So. The reason we have been constructing this relationship between attorney and client is so you'll see the fundamental building blocks of that relationship. And so when we turn to the conflicts material, that's really going to resonate with you because you're going to be thinking, well, there is this requirement of undivided loyalty, competence, candor, communication, diligence, advocacy, client as advisor, all these things. But after we set up all of these things, you're going to see that they can be easily interfered with by things that come outside of the attorney-client relationship. And so it's important that we look at these building blocks. So in our last class, what we did was we started putting together this attorney-client relationship and made the important point that it doesn't matter if there's a contract, official contract, or money exchanges hands, or anything like that. We are looking at what the client thinks and what the attorney thinks. And of course, we saw in the Talkstack case that it was what the client thought. The attorney really had a totally different understanding about this meeting, and that was important because we established that an attorney-client relationship can be consummated without money exchanging hands or formal contract being signed. And that's what Talkstack illustrated. So the entire thing when we looked at the Talkstack case was reliance. Remember, she relied upon all of this discussion with the attorney, so much so that she didn't even go and get any other information. And that reliance cost her. And the court said it was perfectly fair to say that the firm should pay $650,000. Because notice, the reason I put a star next to letter B is because that's really the most difficult component to prove in a malpractice action, the case within a case. I mean, we have a relationship, we have a reliance, we have negligent advice leading to foreseeable injury, we have the attorney not performing competently. But what you have to prove in every malpractice case is, but for this type of negligence, this injury would not have occurred. And you see the court concludes that this negligence was so severe that the court is perfectly confident saying that there should be a recovery in this case. So that was a super malpractice that we spent some time on. And then we talked about express and implied authority. We know that the attorney is the agent of the client. Talked about that a little bit. That's on page 191. Talked about actual authority that can be expressed or implied, and then apparent authority that has to be something that is observed outside of the attorney-client relationship. That's on page 191. We talked about competence. And we hadn't done the washing machine case. And I think the last thing I said was, there's no real malpractice issue here. The reason this case is in the book is to illustrate maybe what you should do in approaching a case. Now, I think the last thing I said was, this is on page 196. You'll be perfectly fine just settling this case. That'd be perfectly fine. But I guess my question is there something more you should do before entering into a settlement agreement? And I think that's where we left off. So, is there something more that we should do? Even though a quick settlement is a community norm, so I'm telling you, we don't have an issue of competence or malpractice or anything. If you want to move on to the next case and just settle this thing, of course the client will give you consent to do that, you would do it, and that would be that. But is that the right approach? So what I'm asking is, would you just say, okay, settle it, that's good, I can move on and make some more money and keep moving? Or are there some things you want to consider before you go this morning at this time?
I'm just concerned that the client knows that they're going to pay an additional $650. I've got.
I didn't hear you went down.
After that, see what you feel.
Yeah. Yeah. So the original price is $720, we ended up paying $770. Our client said I might be able to do that at $50 more than the original price. So I think that's fine. You can kind of leave it at that. And I'm not saying go overboard either. I'm not saying go write a treatise and then analyze it in other states and then write a brief and then charge the client like $10,000 for that. I'm not suggesting that. Just suggesting there are a couple more little incremental things that you should do before you enter into this settlement. Just offering them this way.
Well, if you're being offered a settlement, it's
Yeah.
not your fault to make a client.
That's right.
Client.
That's right.
The only exception would be is if your client is giving you specific instructions beforehand, saying like, for example, if they offer like above this amount, go ahead and
Oh, yeah.
or like I won't sell your. So unless you are following some explicit instructions given by the client beforehand, you need to consult the client. Not every language you can make on your own.
Okay, that's good. That's good. So we know that in the rules. We have to honor our clients' wishes. We have to communicate with the clients. We even have a rule that says that, and I think everything you said in your answer is fine. But what I'm getting at is, should you use your expertise to do something else? This way.
So in this case, I would look at the type of contract that we assigned and see if it comported to like the consumer credit laws to make sure it's a legal contract and all the terms and conditions in it were right. And if the client had some other means of getting out of the contract, maybe giving a washing, maybe they had to take a washing machine back. You can't know that without doing the proper research.
Okay, good. So what led you to that? Because I could see somebody saying, well, this is a real case, a clinic case that Professor Lerman did, and so that's why I said, but real case. And in this particular jurisdiction, the community norm was just to settle these things. This would be a fine settlement if you did that based upon what your client told you. Notice you have Rule 1.4, which says communication. We shall properly inform the client, get informed consent, as Ms. Harper talked about. Reasonably consult with the client, keep the client reasonably informed, and we do all of that. But what makes you say I'd do a little bit more research before I would settle?
Honestly, because of secure transactions, I know that this would be an issue.
That's perfect. Yeah, all the cases all the classes coming up. That's good. Well, and that's good. And so you have to make this determination. And that's what we're talking. We're talking. I haven't said it, but competence. Now, competence in this scenario can mean any number of things. If the community norm is settled, you could settle perfectly fine. But what I'm suggesting is before you settle, this takes a little bit more time to look at governing law. And notice that is what actually happened in this case. In this particular case, you could look at state or federal law, the right to rescind. Did the seller materially misrepresent the product? Are there related service warranties? If so, does the buyer have a right to rescind? Did the seller make required disclosures? And you know, you can get all this out of the little contract that comes with the washer from Sears. So you just pull it out and you look at all this fine print. Did the seller harass the buyer? Did the contract contain required terms under state law? Is even this price unconscionable? So what I'm suggesting is that's a lot of stuff, but before you settle, perhaps there's some more facts that you should collect before entering into this settlement negotiation. Examine those contract documents, thoroughly interview the client. That's part of communication. And really, we're talking about what varying ranges do we have for competence. So as I said, in this particular scenario, quick settlement was the norm. So you would have been perfectly fine just saying, boom, that's fine. $50 more, that's okay. My client says that he can do it, we consulted, and that would be fine. But you know, in real life, something different happened. So the students bring in this proposed settlement. They didn't do any legal or factual research or anything. This is the settlement. And then Professor Lerman, who was supervising this case, she urged them to look into the client's legal rights. What are those legal rights in the context of settlement? One of the students was clerking for a local judge, and that student asked the judge, and the judge even said, well, you can just settle this case. That's the community norm. No big deal. Quick settlement is the community norm. But then the students began to read up on consumer law in the state. They discovered a powerful debt harassment statute that gave the consumer the right to keep goods and not pay the bill if the merchant had engaged in telephone debt harassment. The students then asked the client, how did the store attempt to collect this debt? And lo and behold, they found out that the retailer had made more than 40 calls to their client's disabled parents' home. He didn't have a phone. And some of these calls came late at night. And because this harassment was so extreme, they decided to take it to court. The students decided to go to trial. The retailer then dropped the claim against the clients on the morning that the trial was to begin. So that's just an example. Now, again, I'm not suggesting that you spend like 100 hours every week researching this and drawing up a beautiful brief and then filing that in the district court and going all the way up to the Supreme Court. Not that. But just in order to contextualize this settlement and what it really means, I think you have to do a little bit more factual and legal research. And that's competence. So we showed that there's a broad range of competence. Your standard would not fall below competence if community norm is quick settlement. But this is an example of doing just a little bit more and it enhancing your client's position. Competence in criminal trials. Now, I don't know if this is the bottom of page 197. Strickland is the case. So notice what we're doing here. When we're talking about criminal cases, we're not only talking about Rule 1.1, we are talking about the Sixth Amendment. So you have competence, and you also have the Sixth Amendment. You know, does the right to confrontation mean anything if your attorney isn't performing up to par? And so what does that mean? Someone tell me what this Strickland standard is. Is it a meaningful standard? This is about page 197. And maybe this is the way to analyze it. So, in this case, Strickland, do you think that the lawyer's conduct fell below the standard of care that we would expect from a criminal defense attorney? Was he incompetent? And what does this case tell us about the standard? What you have here is going to be a fairly deferential standard. But even with that, what I'm asking is, do you think this attorney's conduct is incompetent? Essentially doesn't do any interviews or anything, kind of, I'll put this in quotation marks, takes a bet that because the client is somewhat remorseful and contrite, that the judge will give the client a break. You accept responsibility. And so if you look on page 198, there's a lot of things that, this is William Tunke, a lot of things that he did not do. And I want to know, is that incompetent? So the defendant, Washington, confessed against Tunke's advice, but also Tunke did not present mitigation evidence, did not meet with his client's wife or mother, did not seek out character witnesses, did not obtain a psychiatric evaluation, did not introduce evidence about Washington's prior criminal record. No mitigation evidence presented. All of this was done, I guess, because Tunke thinks that since his client is showing some remorse, the judge will be more lenient. Tunke hoped the judge would be merciful because Washington had expressed remorse. His client takes responsibility for his client's crimes. And so I guess the attorney is making a prediction that the trial judge will react to this in a certain way. Isn't this incompetent? Yes.
Yeah, I mean, I think that even though ultimately the court did not find that the attorney was incompetent, I don't think this is a good idea, like, to take that kind of risk and not have collected all of the evidence, and have any kind of plan B for it if it doesn't go the way you get.
Yeah, but that's interesting. So how does the court come to the conclusion that this is okay? What about this standard in Strickland?
Well,
I mean, to me, it seems like you would never win on this type of standard.
Doesn't it outline a two-pronged test?
Yeah. So tell me about that.
So the first prong is to constitute ineffective assistance of counsel under the Constitution, the lawyer's errors must be very serious, so serious that the counsel was not functioning as the counsel guaranteed the defendant by that amendment.
Wow. So there's some cases where, in the death penalty case, the attorney is asleep. And that's not incompetence because he wasn't asleep for the entire trial. He woke up at some point. Or the counsel is inebriated. Well, yeah, that's a little bit, but we can't really be sure that this defendant would want any. This is really deferential. So counsel was not functioning as counsel. And then the other, what's the second prong? That's almost like a case within a case.
The client has to show with a reasonable probability that but for the lawyer's errors, the proceeding would have been different.
So you're not even functioning as counsel, and but for those errors, you probably would have won. And so that's really deferential. These unprofessional errors, the result would have been different. And I guess the overall question within these two problems is, did the error affect the outcome? And here the court says, no. How can the court reach that conclusion that the conduct of counsel cannot be found unreasonable here?
The court says that because the attorney reasonably relied on what he knew of the judge's reputation, and that his conduct was not unreasonable.
Yeah. So I guess this is a strategic choice, and as such, it is insulated from scrutiny, and that's fine. So,
I would defend the case because it seems that incompetent that the attorney did not take aggravating factors into account. Did he not expect the judge to take those into account as well?
Mhm.
To just, not offer mitigating evidence because you're scared that, there might be contrary evidence offered by prosecution. That's leaving it open to us having only aggravating factors considered.
right, and so and really, how can you say that this is a full record if you don't even produce character witness? And I think what you're getting at in Justice Marshall's dissent, bottom of page 199, he would view that this is incompetent because the court really doesn't articulate a standard other than being entirely deferential and outcome determinative. And he says this character evidence is valuable. There's a significant chance, he would argue, that Washington could have received a life sentence rather than a death penalty if some of this character evidence had been introduced. So it seems like, particularly when you have the standard that we have under 1.1, competence, as well as a constitutional right, that this type of conduct falls below the standard. So there should be a duty to investigate. You see on the top of page 201, the duty to investigate exists regardless of the accused admissions or statements to defense counsel of facts constituting guilt on the accused stated desire to plead guilty. So there's a level of competence that the attorney must meet that is solely distinct and apart from a client just saying, I'm guilty. So if your client says, I'm guilty, I admit, accept full responsibility, that doesn't mean you just say, okay, well, we give up and that's that. And it seems to be that's what this attorney did in this particular case. You notice, look on page 202, and I think this carries forward to today. Defendants prevailed on claims of ineffective assistance of counsel in only 4% of cases reported after Strickland. So highly deferential standard. It's almost like you didn't have an attorney, there was someone there claiming and pretending to be an attorney, and this error was so severe that we don't even have confidence in the outcome of this proceeding. And that's very hard to me, very hard to me. Now, starting on page 204, there are a series of cases where ineffective assistance of counsel was found. So what makes these cases unique? One comes out of Kentucky Padilla. So in each of these cases, and this is something rare, the court found Sixth Amendment violations. What about these cases? So this must be something really bad because we just said that Strickland has this very deferential standard. And even on page 204, you have an example of a case that occurred in our very own Sixth Circuit, where a sleeping lawyer is not ineffective. That really shows that the case within the case is really difficult to prove. And notice the reasoning here. The defendant, Nunez, did not receive ineffective assistance of counsel, even though his lawyer slept through part of the cross-examination. So you have a lawyer who isn't even listening to the questions in order to deal with the cross-examination of his client. So there's some objections that were not made to preserve the record. Didn't really deal with impermissible prosecution questions because he's asleep. The court reasoned that the lawyer's mouth was only brief, so since it was only a small period of time, you're looking at the overall proceeding, and notice how difficult it is to prove the case within the case. We can't say that if he had been awake the whole time, the result would have been different. That's interesting. So, what makes Padilla, Fry, and Cooper different? All violations of the Sixth Amendment. They violated what?
The lawyers actually all violated both special evidence.
Yeah, that's right. But couldn't we say that about Strickland? I mean, we sort of say that about Strickland, even though they come out and say no, ineffective assistance of counsel. And I think you're right, but what makes these cases, I guess, distinguishable from Strickland?
Well, in this particular instance, these also deal with communication.
A little bit louder.
These also deal with communication with the client, like actually telling them, what the contents are. And
Okay. Oh, that's interesting. So you're saying we have, across all of these, we have competence, communication, and then the attorney does something that injures the client. Competence, communication, and the Sixth Amendment. So, what was incompetent in Padilla? All of these are ineffective assistance of counsel.
Lydia's attorney didn't tell them
Look it
that.
up.
Lydia's attorney didn't tell them that he said that he would have issues with immigration since he'd been in the country for so long.
Yeah.
But that wasn't true because he was found guilty, then he deported.
Right.
He pled guilty, and then of course he said ineffective.
Yeah. Isn't that crazy though? Immigration law is one of the most complicated areas of law. And notice what this attorney did. This is worse than Talks said. He didn't even go into, you've been here like 40 years, so you're a citizen, that's cool. And so, notice, so Padilla is an example where you have failure to provide accurate advice to a non-citizen that equals ineffective assistance of counsel. Prejudicial impact is devastating here. And so, you have the U.S. Supreme Court finding a violation of the Sixth Amendment when the lawyer did not know the law. This is not a strategic choice like in Strickland. And there's some argument about whether or not this is a strategic choice in Strickland, but at least you could say the lawyer did some analysis, made some predictions. That may be the wrong way to approach the practice of law, but at least the attorney made some type of critical assessment within the scope of his competence. So it's easy to say that this is a strategic choice. In these three cases, Padilla, Fry, and Cooper, you have on some level basic competence. Lawyer didn't even know the law. So Padilla is the failure to provide accurate advice. Non-citizen. Is an effective assistant of counsel. So that's something basic like knowing the law. What about a Fry? Yeah.
It's the failure to let the client know of a formal plea agreement.
Yeah. So notice we're building upon competence, communication, and then we have this constitutional right. So notice this is a failure to communicate a plea offer that ultimately lapses. Ineffective assistant of counsel. So notice here again, there might be prejudicial impact to Strickland, but it is at least superficially characterized as a strategic choice. You know about this judge, you made this decision not to present this character evidence. You can even make the argument that if we do produce this character evidence, knowing those of you in evidence know that the prosecution can respond, so maybe the defense counsel said, I don't want to take that risk. So that looks more like a strategic choice. And the prejudicial impact in Strickland is a little bit less because you have a defendant, even though it's against the advice of counsel, who says, yes, I'm guilty. Here, we have competence, not even knowing the law and advising someone the wrong way. Here, letting a favorable alternative to your client's lapse because you don't communicate. Prejudicial impact again. And what about Cooper? And another way to think about this is those three cases, all ineffective assistance of counsel, all of them show defaults in competence, communication, how you communicate with the client, not putting in enough work to understand what the law is, and then actually undermining your client's Sixth Amendment rights. Yes, go ahead.
I'm just saying, Cooper goes with the Fry case, but it's not telling his client, gives his client bad advice on not accepting the plea deal. He says, basically, away with it.
Yeah. So a lot of these cases make me nervous because you see this attorney sort of not even practicing law competently or even looking at the law. It's just sort of making, I guess, factual decisions. Look on page 207. Cooper's lawyer, this is the erroneous advice. It's a clear violation of competence. Cooper's lawyer told him that he could not be convicted of the charged offense because the 4 bullets had struck his victim below the waist. I guess it's not really murder because it's not, but I don't know. But yeah, and that's crazy. So that isn't, and this is probably a lawyer saying I'm just doing a common sense reasoning. This is what, but that is a core failure. So here we have a counsel offer inaccurate legal advice that led the defendant to reject a favorable plea. It's ineffective assistance of counsel. So even though Strickland is highly deferential, these three cases represent a basic core failure of the lawyer's duty in terms of competence, in terms of communication, that undermines the Sixth Amendment right, confrontation, and you have ineffective assistance of counsel in all three cases. So Fry, also the book points out, constitutionalizes the ethical duty of a defense lawyer to communicate an offer of a plea bargain to her client. So notice, this is an example when we first started of me saying, well, you'll be governed by other law too, because here we have our basic competency standard as well as the Sixth Amendment right to counsel. So that's going to be important. Look at this next problem on page 208. So the reason this is in the book is we've just been having this discussion is now we're going to take this notion of competence and see what it actually means in a practical situation. So we have a situation where it is very close to trial. We represent Ellis Boyko. We speak for the client only for about like 20 minutes. So things are moving. There might be 5 witnesses that support our client's defense. At least 2 of them we know will definitely support the defendant's self-defense claim because the prosecution is not going to call those witnesses. So what we're getting here is a chance to look at Rule 1.1 competence in the Sixth Amendment. And the judge calls the case. We want to interview 2 other witnesses before the case goes to trial. So we have an opportunity to present their testimony if it's helpful to our client, or we can use this information as a basis for cross-examination of the prosecution witness. So at the very least, we want to get to these 2 witnesses because they might be helpful to our cause. The judge calls the case, explains that, you explain that we just received the file, we haven't had an opportunity to investigate, and we want a postponement of just 1 week, or maybe 2, so that we can interview the witnesses of the alleged assault. The judge said, well, it's almost lunchtime, I'm going to recess this for lunch break, I'm not going to give any postponement, you can interview those clients during the break, and then we're going to hold this trial this afternoon. During the lunch break, we don't have a chance to interview anyone. We don't want to go to trial until we have had a chance to interview all of these witnesses so we can make a strong defense. And we don't want to be limited by just the witnesses that the prosecution has identified. They're just going to be favorable to the prosecution, and the best that we're going to be able to do is cross-examine to undermine their credibility. We want our own substantive witnesses to help us advance our defense. Court just reconvenes. We repeat our plea to the judge. We're not prepared to proceed. and we want to request a short postponement. The judge says, I order you to proceed. If you do not do so, you will be held in criminal contempt, taken to jail immediately. Notice this. This is your safety net, the court says. If your client is convicted, he can just appeal on the basis of ineffective assistance of counsel. What do we do? What do we do? I'll call on you, Ms. Harper. Somebody else about it. Let me see.
I guess you go to jail.
Huh?
I guess you go to jail.
Yeah, you go. Just tell me about that.
Well,
Yeah, I mean, this-
the judge is not a fair trial by not giving you, reasonable time frame to get all the information and help your client in the case.
And you would stand up and say, no, I'm not doing it. Yeah, that's good. That's good. So are you just saying that because we're in the classroom, or you're serious? Yeah, you're right. I'm just trying to.
Trial, I probably would.
I mean, so I guess what I'm getting, this happens, a lot. I wouldn't say every day, but people are swamped. You're trying to move this forward, but you identify something that's important. What are you saying that competence means here? You said we're not getting a fair trial if the court makes you proceed. What are you saying about fair trial? What are you saying about the right of confrontation too?
Yeah, well, I mean, you haven't had the opportunity, even with the people at the court meeting interview, you still don't have all people that complications qualities required.
Mhm.
You get an interview.
Mhm.
Those people, should also be put on the stand and just that
Mhm.
the client has that right.
So notice that this is on a number of different levels. So as a basic Sixth Amendment confrontation clause, you would be on some level sacrificing your client's right to confront. You really don't have anything to confront except what the prosecution provides. That's a problem. And then as a basic level of competence, we can't really say that you're fully prepared. We can't really say that an attorney has reasonably done all the work to make sure that he or she is competent to move this case forward. Ms. Harper, go ahead.
This appears going back on what Neil said. I mean, first off, the judges, I don't think Judge Wright was saying, like, no basis of ineffective account, because in this case, counsel is trying to be competent by saying, at this moment, I'm not competent to
Right.
proceed with this case. And you are forcing me to not only allow a violation of my client's constitutional projects, you are forcing me to represent me in confidence. I am not having confidence to prepare this.
That's true.
So it's really a blame on the judge, not the lawyer.
And also, I think the judge is wrong because we just talked about how high the standard is. It would be very difficult for the defendant to meet this standard, that counsel is not functioning as counsel, probably because of the arguments that you just made, that he is trying to do everything that he can to be fully prepared, so we can't say he's not functioning as counsel. And then, but for counsel's unprofessional errors, there will be no unprofessional errors, even though it is incomplete. You can see a court looking deferentially back at this after the attorney proceeds and just say, well, the attorney did the best he could with what he had, and that's that. No ineffective assistance of counsel. So I think the judge is wrong there as well. So, what do you think happened? This happened in Portage County, Ohio. So you have an assistant public defender, and as Mr. Baker said, he refused. He said, I'm not going forward. And so, like you said, he's taken into custody. Later that day, he's released on bond. The judge sets a hearing on the contempt charge, and the public defender requested another judge order the judge who was presiding not to preside at that hearing, but the other judge refused to do so. At the hearing, there was even a professional responsibility testifying that the lawyer could not competently represent a client under the conditions imposed by the judge. The judge noted that, well, this is what happens all the time. Public defenders regularly plead their clients guilty only minutes after meeting them, he said, without any investigation. It's just a system function. This is what happens in these high-volume courts, and that's that. He then sentenced the public defender to 3 days in jail, suspended if he pays court costs, and lost wages to the witnesses who had to appear. Jones appeals, and that's the public defender. The appellate court reverses, stating that the judge's denial of a postponement was an abuse of discretion. It cited the lawyer's obligation to provide competent representation under Rule 1.1 and the Sixth Amendment, and stated that it would be unethical for the public defender to proceed with trial, because that public defender would be putting his client's constitutional rights at risk. It also noted that this judge's statement that just filed the Sixth Amendment ineffective assistance of counsel was not satisfactory, because the higher burden of proving prejudice, but for these unprofessional errors, was really too high of a burden to place upon the defendant. In other words, the defendant could not meet that burden. So amazingly, the state prosecution's office, they appealed to the Ohio Supreme Court. The court refuses to hear the appeal, and that's that. But notice this, after about a year later, the judge's term ends, he begins to practice law. The Ohio Supreme Court suspends his license based upon 10 violations of the Code of Judicial Conduct while he was on the bench. So notice he leaves the bench, they find these violations that he did while he was on the bench, and his license is suspended as an attorney. He failed to maintain proper records, and in one case he met with the prosecutor without the defense attorney being present. So he sort of condoned an ex parte meeting. No. When his suspension was finished, he then resumed the practice of law. But here's a judge who did this, and then when he goes into practice, his license is suspended for violation of the Code of Judicial Conduct. Interesting. Diligence. Look on page 209. You have this rule 1.3. And some of these things you'll say, well, that's just common sense. But what do you think it's probably our shortest rule. Why do you think we have to have a rule that just says work hard, and then what does it mean? Diligence. A lawyer shall act with reasonable diligence and promptness in representing a client. That doesn't tell us much. How do we approach that in practice? In other words, I think people work differently. Everybody in this room probably approaches things differently in terms of work. We all get it done, but we may do it differently. So how do we know what diligence is? Do the comments give us any guidance beyond work hard? The lawyer should act with reasonable diligence. So my reasonable might be different than yours. So how can we enforce this? I mean, comment 3, you have something like, one of the worst things you can do is procrastinate. That's not helping us. And comment 3 says, perhaps no professional shortcoming is more widely resented than procrastination. So a client's interest can be adversely affected by the passage of time and changing conditions. In extreme circumstances, when a lawyer overlooks the statute of limitations. But how do we know what reasonable diligence and promptness is? What is? So I get a new matter in, I start working on it immediately. It comes in at 11, I have another matter I'm working on, I take lunch, then I come back at 1 o'clock and start working on it immediately. Somebody else might get it and say, well, it's Friday, I'm not going to be in office Monday, I'll start working on first thing Tuesday. Or there might be some people who say, well, I'll get back to it next month and I'll call the client every now and then. So I mean, yeah, go ahead.
Well, it says that the opposite is total neglect of client cases.
Right.
I would assume that reasonable diligence, even though you said, I mean, everyone works differently, I would assume it would just be, so long as there's not any opportunity or you let a deadline go by, anything like that, then you are reasonably diligent in the process. So as long as you don't fail to do something that you should have done in the course of the case or litigation or whatever, then you're technically diligent.
That's good. And so notice that, that's good. So you have to be careful. There's no way that they could put in a right line rule that would govern all our conduct, because notice we have a tremendous amount of discretion as an attorney, and the rules are constructed so we can exercise that discretion in a way that's beneficial to the client. So the touchstone here is reasonable diligence and promptness within the context of the client's case and how you work. But one thing should be a guiding principle, and that is do not do anything that would adversely affect or prejudice the client's interest. It's more.
I was going to say the same cross reference, rule 1.08 that reasonable is the reasonable and competent lawyer.
Look it out.
Just so that we're looking at diligence, we're looking at the reasonable lawyer.
Okay. So how do we discern what a reasonable prudent lawyer is, though? And I asked that question because we sort of had that with Talkstat. Notice. It's the same thing. This attorney failed to perform in a manner that an ordinarily prudent attorney would perform in. So there's going to be some community norms about how law is practiced on particular cases, and that is what we're going to adhere to. So there are going to be some time limits, perhaps in the courtroom, or just matters of general practice, and that is what is going to help us determine. So the context of our practice is going to help us understand what reasonable preparedness is as well. Candor in communication on page 211. Is it ever okay to lie? No, but this comes back to moral arguments that we talked about before. So we know that we can't assist the client in committing a crime or fraud. We know that. We also know that we have this rule about confidences, that there are some things that we might have to not disclose, some things that we have to protect. And so that could be a form of dishonesty too. We can't tell everything about our client, but it's our duty to protect that information. You see on the top of page 213, there are many circumstances when our role requires us to withhold information. And also when we present information, whether we're talking about a pleading or a letter or different arguments we make, of course, to advance our client's claim, we may be selective in how we use the facts. And that's completely different than lying. That is focusing on the facts that help your client. Page 214, look at rule 1.4. That's just the chart, but I have the rule. So you see a number of things about this rule. And notice competence is our first rule, but everything below that builds upon that. You have to be honest with the client, and as an officer of the court, you have to communicate with the client. You have to perform things with reasonable diligence and promptness. All of that relates to competence. And one of the most important subcomponents of competence is being able to know what the client wants. I mean, communication is also going to help us define what we are actually going to do for the client. That's the scope of representation. So this rule is important because it really, since we're talking about relationships between lawyers and clients, we're really talking about how the lawyer and client collaborate and form the parameters of the representation. And there's no way to do that without communicating with the client. So what does 1.4 tell us? What jumps out at you, the rule? So if you look in the chart on page 214, there's some things in bold letters that sort of highlight the essential components of this rule. This rule is mandatory. A lawyer shall. So promptly inform the client of any decision or circumstance with respect to which the client's informed consent is required. So any move that you take that's going to impact the client's interest and that the client needs to sign off on, you need to communicate that to the client. We've been saying informed consent over and over again. What is informed consent? How do we know what that is? Is it, yeah, I told you about that yesterday in my email? Is it like, I need to do this? Then the client says, okay. Is that informed consent? What is informed consent then?
You've given the client, you told them about any consequences from making a decision one way or the other, and they have thought about it, and you can send it to their client.
Right, right. And you don't want the situation to ever come around that where the client says, well, I didn't know we were going to do that. I thought it meant this. Or, why did you do that? I didn't give you permission to do that. Because notice, the attorney on some level might think that he or she is impliedly authorized to carry this out. I mean, if it's just a normal matter like a document request or securing some information to help advance the representation, that's one thing. But if it's a major decision that's going to impact the client's interest, the client needs to know the pros, cons, and consequences of adopting this particular course of action. So there needs to be a critical exchange between the attorney and client so that we can say that there indeed was informed consent. That's what 1.4a says. 1.4a1 says, 1.4a1a2 says, consult with the client about the means by which the client's objectives are to be accomplished. So the client tells us the objectives, the goals. the ends, and we use our expertise to tell the client this is how we can achieve those goals. Keep the client reasonably informed about the status of the matter. That's 1.483. Reasonable request for information. That's 4. We respond. Consult with the client about any relevant limitation on the lawyer's conduct. Now that's going to be important. That's sort of a prelude to conflict. So notice, you may take on a representation, and as time goes on, you realize that there's some things that you cannot do because either a current interest, we're going to talk about concurrent conflict, or something that you've done in the past, a former client. So that's a conversation that has to occur because the client needs to know the scope of the representation again. The scope of the representation can change during the course of the relationship. So when the lawyer knows that the client expects assistance not permitted by rules of professional responsibility. So other than a conflict, it may come to a scenario where the client says, I want you to file these papers. I know some of it is not totally true, but we can just fudge on it and it'll make a good presentation. We can get the zoning ordinance where you have to say, our previous discussion, even though we have confidence under 1.6, I cannot assist you in criminal or fraudulent conduct. Disclosure would be mandatory if we went down this road, so you shouldn't do it. And so that's a form of communication as well. And then finally, I would say 1.4a really deals with relationship between the lawyer and client. 1.4b talks about the lawyer's duties. The lawyer has to explain the matter to the client. Now, when you're doing this in real life, keep in mind that you have to look at these comments. So one thing I want to emphasize is comment 5. How would you go about explaining something to a client? I mean, it could be a complex matter, it could be sort of a simple matter, but what would be your approach in explaining something to a client? So you have to keep a lot of things in mind when you're communicating. How will you advance this matter in terms of your competence? How open are you going to be? What is the scope of representation? All these things. Go ahead.
I was just saying, in their own language.
Tell me what you mean by that.
You kind of take your client into account in this way, their own education, their culture, history, make sure that they understand.
Mm-hmm. Make sure that they understand that when you're explaining to them, what is your goal in explaining these things to the client? You want to make sure all these things are functioning well. The only way you do that is to communicate with the client because the client, whatever level of educational skills, should be able to help you advance this matter or claim. Look at comment 5. Clients should have sufficient information to participate intelligently in decisions concerning the objectives of the representation. You know, this conversation is also going to inform the client. And maybe the client will say, oh, maybe I really don't want to do it that way. Maybe that's not even what I want. This is what I want. And so one major component of communication is that you're setting the objectives of what you and the client are doing together. This helps with determining the scope of representation. And so you want the client to be able to participate meaningfully in this representation. Adequacy of communication depends in part on the kind of advice or assistance that is involved. So it's a balance. You look further down in comment 5. A lawyer ordinarily will not be expected to describe trial and negotiation strategy in detail. So you're not going to take a client and say, well, we're going to this deposition, and I'm going to ask these 5 questions, and this is what it's going to do, and this is the answer I hope to get, and then I'm going to summarize this in my notes. You just give them enough so that they can participate effectively in the representation. And all of that is going to depend upon context. Some clients may want more details than others. And so comment 5 to rule 1.4 is important because it's going to help you understand how to conduct that communication. And I guess the important thing to take away from it is this. This is towards the end of comment 5. The guiding principle is that the lawyer should fulfill reasonable client expectations for information consistent with the duty to act in the client's best interest and the client's overall requirements as to the character of the representation. Along with the way of saying we're going to look at context, we're going to look at what type of information the client needs in this particular matter, and that's how you will communicate. So communication on some level is going to be different. You see that on top of page 215. Fiduciary duty. I mentioned that earlier as well. This isn't really a rule, more so that than there's a product of our position. We have a unique position that requires a unique level of trust. You see that on page 215. Candor in counseling. So we have 2 types of candors. We have a candor towards the tribunal, and then we have a candor in counseling. If you look on the top of page 217. So I would say 1.4 is more of the general communication, keeping the client informed. This is how you should communicate. This is what you should talk about. This is how you balance within context. And 2.1 on page 217 is a little bit different. It talks about the attorney's role in communicating. Let me see. Okay, advisor. The key component here is independent judgment. So 1.4 communication is sort of the nuts and bolts discussion. Keep the client informed. Here's how you talk to the client. Here's how you balance those interests. This is more our role. This describes the role of a lawyer as counselor. Most important thing is independent judgment. So in 2.1, we have to render independent judgment. And candid advice. And so notice we're sort of still moving towards conflicts. If an attorney cannot exercise independent judgment, that's going to be a clear sign of a conflict as well. And we're going to see over and over again that when an attorney cannot exercise all of the options that he or she normally would, that sort of shows you that there might be some limitation in the representation. And that's going to tell us it might be a conflict. So just, this is sort of making the case book come alive. So you have to have independent judgment and render candid advice. How do you deliver bad news to a client? You have a particularly demanding client, whatever the context, and you have to deliver bad news. Do you give them all of the news? Do you try to be sort of neutral and not really specific about the impact? Do you sugarcoat it, or do you give it to them straight? Client says, how bad is it? No, criminal case. How bad is it? Or a contract security case. How bad is it? You say, oh, not really bad. I think you can get out of it. But how do you deliver that bad news? And I'm getting that comment 1 to 2.1. Legal advice often involves unpleasant facts and alternatives. And it says the lawyer should not be deterred in delivering this bad information to the client simply because you're afraid of what the client's reaction might be. How would you deliver bad news? What's that?
I think sticking with the independent judgment part of it, you can use your own judgment and what you know about the client, your previous relationships to couch news and in a way to sit best with them, but still in a way that is very candid about the effects on that person's human rights.
Okay.
As long as you're getting that part through, you can, not necessarily, display in a way that will sit best with them.
Okay, so a couple things you said that sort of you said couch it so that they can accept it, and then give the information in a way that sort of sits well with them. How much would you give them? And this is really bad news. The corporation has committed fraud. There are going to be substantial fines. Some people are going to go to jail. The president comes to you and says, I know you don't represent me, but I'm still really concerned about the corporation. How bad is it? You think we can get out of it? Everything's going to be okay? It's not really as bad as it seems, is it?
Okay, you guys say yes.
And so, yeah, you have to say it that way. And we laugh because that sort of makes us uncomfortable, but we have to sort of be able to get that uncomfortable information across. That's part of candor. So you notice that candor runs through the rules as well. We have to be candid towards the tribunal, so that may mean the same things that we may be uncomfortable with. And delivering bad news to a client. Now, turn to page 218. You've heard this, probably older attorneys always say this, represent the client zealously within the bounds of the law, and that sort of got out of hand. That used to be an actual rule within the code, but the concern was that attorneys were reverting to that language to do just about anything to win. And the response would be, well, I'm representing my client zealously within the bounds of the law. You see on page 218, that is now taken out of the obsolete code of professional responsibility, and it's just mentioned in some of the comments. Zealous advocacy is a component in the comments, so it's not an actual rule. You cannot waive the duty of competence, and you cannot prescriptively limit malpractice liability. So you can't enter into a contract with a client and say that you absolve me of any and all negligence, real or imagined, and I'm permanently insulated from any claim. You can't even bring a claim of malpractice against me. You can't do that. These rules would be meaningless if you could contract them away. And you have that on page 220. I want to turn to rule 1.2. Break that down. Look on page 227, 1.2. Scope of representation. So it's interesting how all of these sort of rules sort of go into each other. You won't even understand the scope of representation unless you communicate with the client. And so that's why so much time is spent in 1.4 talking about the relationship between the attorney and client and how they must communicate. So if you look at this chart on page 227, and some of you have already mentioned this, notice it's cross-referenced to rule 1.4. So a lawyer shall abide by the client's decision concerning the objectives of representation. We already know that we are agents of the client. The client determines objectives and goals, and we determine the means through our expertise. Notice, and as required by 1.4, shall consult with the client as to the means by which they are to be pursued. We can take action that's impliedly authorized to carry out the representation. So, all discovery, motion practice, letters, phone calls, we don't have to go back and ask the client each time that we do that. We're moving the matter forward. The lawyer shall abide by a client's decision whether to settle a matter. Cannot settle a matter without the client's informed consent. So that's another component of communication. We are acting on behalf of the client. In a criminal case, the lawyer shall abide by the client's decision as to the plea entered. Another aspect of 1.2b is just because the general public doesn't understand this rule, but we do. Just because we represent someone does not mean that we are endorsing their beliefs or political, economic, or social views. Famous example of that is the ACLU representing the Nazis and Skokie. Not representing the Nazis, but the broader principle of the marketplace of ideas, First Amendment, and that type of thing. But the general public will say, why are you representing them? So that's 1.2b. 1.2c says the lawyer may limit the scope of the representation if the limitation is reasonable. So that comes from communication as well. The attorney and client have to talk about common objectives and how they will be achieved. And it may be necessary for the lawyers to say, representation is limited here. So maybe it's a trial attorney, and the trial attorney says, I'll take this all the way to trial. I don't do appellate work. If this goes to an appeal to the Sixth Circuit, you may have to get different representation. And then 1.2d, we already know, shall not engage or assist the client in criminal or fraudulent conduct. But we can discuss the legality of certain conduct in order to effectively advise the client. That's 1.2d. Now, Jones versus Barnes on page 229 sort of makes this point. And it's sort of building upon the Sixth Amendment. So we have this deferential standard under the Sixth Amendment. There we were talking about competency. Now in Jones versus Barnes, we're talking about competence again, but here the question is, what must the attorney do in order to be perceived as competent? Here the court ultimately concludes that there's no Sixth Amendment right to instruct counsel on issues to raise on appeal. So here you have a situation, you see on page 229, where the police arrest Barnes. The prosecution is based primarily on some identification testimony. There is some cross-examinations. Barnes' lawyer asked Butts whether he had ever undergone psychiatric examination. The judge directs no further inquiry on that type of question. Barnes is convicted. The appellate court appoints a lawyer to represent Barnes. And there's this discussion between Barnes and his lawyer, Millinger, and he rejects most of Barnes' claims because they were not based upon the trial record. So the attorney is using his expertise and saying these are issues that we certainly can raise upon appeal. All of these other issues that you've given me are not really viable. He told Barnes that he was considering 7 other claims and invites comment. And there is this case called Ferretta that says that there is a personal right to represent yourself constitutionally. But the court concludes that there's no right to compel appointed counsel to press non-frivolous points. If counsel uses her professional judgment to decide that she's not going to present those points. So you can't force counsel to raise each and every non-frivolous issue. There is some level of judgment that the attorney has to exercise, and the court is not willing to sort of micromanage the exercise of that discretion. Upholding the conviction. That's on page 230. But Brennan and Marshall, as they customarily do, dissented in this case. It says, here you have a common situation where the state forces a lawyer on a criminal defendant who's already skeptical of the system. And now you're telling this criminal defendant that his or her arguments are unworthy of further consideration. That undermines individual autonomy and trust. They would argue undermines the Fifth Amendment and the Sixth Amendment. And if these values of individual autonomy are essential to the constitutional rights embodied in the Fifth and Sixth Amendment, then the dissenters say that this case should allow the criminal defendant to fully explore non-frivolous issues. Constitutional rule that encourages lawyers to disregard their client's wishes without compelling need can only exacerbate the client's suspicion of lawyers. So that argument doesn't win the day. It's more deferential, just like Strickland. Strickland says you exercise strategic choices, and we're going to say that there's no Sixth Amendment violation. If you don't raise every non-frivolous claim on appeal, no Sixth Amendment violation there as well. When we come back, we are just going to finish this chapter. We're going to start with diminished capacity, Rule 1.14. And keep in mind how representation works there. You're going to have to figure out how you balance having a normal relationship with the client who may have diminished capacity to understand the representation. Have a good afternoon.